whether or not this is in effect a criminal sanction, and therefore there ought to be criminal protections, right to trial by jury, appointment of defense counsel, the whole 9 yards in terms of what criminal defendants get. And basically, under the test set forth in Brown versus Morano County, this is a crime. You're basically fining somebody up to $10,000. It's a substantial fine. You're condemning them, putting the name on the public website, depriving them of the ability to earn their livelihood, perhaps forever, in Columbia County. That's a serious matter that under the Brown test would be criminal, and yet the procedures called for don't even require determination by a court. It's at least initially with the county commission and then with the justice. Then finally, the final constitutional argument has to do with the two subjects rule. And generally, the courts here on ballot measures have been quite, and the test is same for state legislation, they've been quite liberal in terms of being able to lump together different provisions, as long as there was like one common theme that ran throughout. Then that was considered to be still a single subject. Basically, what you're balancing here under case law is you're balancing on the one side not wanting to have log rolling, which is the putting together different pieces so that that you can pass that which you would not otherwise be able to pass because they're all bound together. And to vote for one thing, you have to vote for the whole thing. You want to prevent that on the one hand, but on the other hand, you don't want to unduly restrict the legislative process so that it becomes unwieldy and cumbersome and you have to pass too many laws. The patience of the court is quite broad with respect to what can be one subject, but in fact, it's not limitless. And in the McIntyre case, which is the sort of predominant, most recent case, the court just said, look, we've got different subjects here. Likewise, we have different subjects with both the measure and with the ordinance. And predominantly, and I'm sorry, I misspoke, with the measure. This argument applies only to the measure. With the measure, essentially what you have is you have a lot of provisions that all have to do with employment of undocumented aliens. And that's all fine and good. But then also there's a provision that says that, and oh, by the way, the county has to pay for this out of the general fund and can't cut any of a number of specified programs, including crime. Half of the general fund is dedicated to crime functions. And so what's left is you have to pay for, you have to do this if you don't, you're engaged in official misconduct. You have to do this out of the general fund. You can't raise taxes, and so you have to somehow get these costs out of the other half of the budget in the general fund that is available to you, which essentially means that you have to rebalance the priorities of the county. This really has to do with spending and
so what you're saying is that not only does it have the function of attempting to prohibit undocumented workers, but also it turns out to be a budgeting bill for the county, that the county is, in essence, said that at least in this one area, you cannot raise your revenue sources, that you have to live within your budget, and so then I suppose suppose you could have to argue that somehow they have to justify any increases as not being in any way related to the enforcement of this ordinance. I mean, it's kind of
I think it's worse than that. Essentially, what they'd have to do is cut programs. They'd have to cut programs that are currently being paid for by that half of the general fund.
You're arguing that it's so severe that essentially it prohibits them from raising taxes.
That's
The only thing they can do is live with their existing tax level and cut whatever other programs may be necessary, because any increase in taxes would be arguably a violation of that restriction.
Exactly. Exactly. Now, I want to address the argument made this morning, though it was not made, as has been pointed out in the briefing, so it's really sort of out of order, but nonetheless, because it goes to subject matter jurisdiction, I did want to address it before, and that is the question of whether this argument is made moot by the fact that the county has adopted the ordinance, and therefore the measure somehow goes out of the picture.
I mean, given the fact that it has the repealer clause, isn't it required that the court consider the validity of the measure?
That's exactly what that was exactly the argument I was making.
With that being included, that would seem to me to cause the court to have to consider the underlying validity of the measure.
Unless the court has more questions, we think that we've aptly demonstrated that this is a unsound, unconstitutional set of provisions that makes no sense, is irrational, and is beyond the legislative authority and the constitutional authority of the county to enact, and we would call upon the court to so declare.
Are you aware of any criminal procedure, criminal prosecution that would be allowed to be initially held in the legislative body of the county? So as the initial determination seems to be with the county commissioners, and only the appeal is in the justice court. If the court accepts your argument that this is essentially a criminal prosecution under the Brown versus Multnomah County criteria, is there any authority for a legislative body of the county commissioners to make an initial determination of guilt? Is that a problem there?
Certainly not without all of the panoply of protections that apply to a...
Do we have a separation of powers issue there with the county commissioners making a determination of guilt? I mean, something is happening at the county commissioner level, and let's say that the individual doesn't appeal. You know, has he then been convicted by a legislative body, and is that something that can occur?
We thought about and looked a bit at the question of separation of powers. The difficulty is that while on the state level there's sort of a pristine separation of powers doctrine, and certainly at the federal level that's true. At the county level, we have a history of counties being executives, but having, you know, county courts used to have lots of judicial kinds of functions, and so I'm troubled by that, but I can't represent to the court that we can state that that definitely would be.
Are you aware that historically